Good morning, ladies and gentlemen. Welcome back to Bexar County Court of Law number 6 in the Bexar County Veterans Treatment Court. I'm Judge Wayne Christian. We have several pleas and motions to revoke probation settings today. Today being Wednesday, 13th of July, 2022. It's approximately 10 a.m. Representing the state in all matters will be Ms. Karina Sanchez. Representing the Bexar County CSCD will be Ms. Susan Gross. So I will swear at this time. Ms. Gross, please raise your right hand. You swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir, I do.
First case I have on my docket is a plea cause 657-691, State of Texas versus Victor Mercedes, represented by Mr. Tony Hernandez. Pat, what's our status on that one?
Your Honor, he said he would be in 15 minutes, and he has the defendant in his office. This is an interpreter, and I have them. I just need to call them and they'll come in.
Great. Next one is cause 658-065 and 658-066, State of Texas versus David De La Fuentes with Randall Griner. Randy, are you ready to proceed on this one?
Yes, Your Honor, we are. But I would like to make an announcement that
Sure.
If you've received an email from my office that says open this, do not open it. I've been a victim of a hack.
Ugh.
So I've been telling clients, no, but some other lawyer sent it to me and then I got it.
Thank you.
Thank you. I don't open yours anyway, Randy. It's okay.
That's true. I put jerky on it.
Okay, then I have motions to revoke probation, cause number 561218, State of Texas versus Miguel Maldonado and Miss Kelly Green. Ms. Pat, do you have a status on Miss Green?
No, Your Honor, because I was in the process of doing things. As soon as y'all get started, I will call Miss Green and let Mr. Maldonado know what's going on.
Hey, Mr. Maldonado, you're with us at this time. What Miss Green is either she is ill or her child is ill. She's got some sort of family issue going on. We're going to try and reset this for tomorrow, either in the morning at 9:30 or the afternoon at 2 o'clock, depending on what fits your schedule and your attorney's schedule. Okay.
Okay.
So if you wouldn't mind just hanging on with us a few more minutes here until Pat calls Miss Green and find out what they want to do. It's either going to be Miss Green or her husband, Judge Barons, that's going to be available for you tomorrow. Would that be okay with you, sir?
Yes, Your Honor.
All right, thank you. Stand by and we'll get back to you here this morning. And I've got cause 550723, State of Texas versus Tri El Ho. I guess with Miss Kramer, is that correct?
Yes,
Judge.
Miss Kramer, are you ready to proceed on Mr. Coe's case?
Yes, Judge, I did want to kind of speak to you about a possibility, but you can go ahead and call the case and I'll just.
Let's go ahead and let me get Mr. De La Fuentes and Mr. Griner out of here, and then we'll come back and chat with you as long as you'd like. I've got the last case I have said is cause 423255, State of Texas versus Charles Hayworth with Adrian Perez. Is Mr. Perez with us? There he is. Yo, Adrian. I just love saying that. Anyway, are you ready to proceed on Mr. Hayworth, sir?
Yes, sir.
All right. We're good. So, Mr. Griner, let's take yours up at this time, and then we'll go back down and see who's ready after we finish with that one. Okay. I've got cause 658065, State of Texas versus David De La Fuente. The first document I'm looking at is entitled Defendant's Consent to Plea by Video Conference, which is purportedly signed both by Mr. De La Fuente and his attorney, Mr. Griner. In fact, Mr. De La Fuente, is this your signature on this document, sir?
Yes, sir, it is.
Thank you. And Mr. Griner, as attorney for Mr. De La Fuente, is this also your signature on this document?
Yes, Your Honor.
Next document I have, Mr. De La Fuente, is entitled Defendant's Waiver of Constitutional Rights and Court's Admonitions, that purports to have your signature on the back, effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. In fact, sir, is this your signature on this document also, sir?
Yes, sir, it is, sir.
By signing this document, are you telling me that you've had enough time to either read this document or have it read to you in its entirety? If you had any questions about what was on this document, those questions were answered to your satisfaction by your attorney, so that in signing this document, you're telling me that you agree with and understand everything on this document. Is that correct, sir?
Yes, sir.
Mr. Griner, as attorney for Mr. De La Fuente, have you had enough time to go over this case with him? And in your opinion, is he mentally competent?
Yes.
Mr. De La Fuente, are you a United States citizen, sir?
Yes, sir, I am.
Thank you. And Mr. Griner, as attorney for Mr. De La Fuente, has the state fully complied with discovery for you on this case?
Yes.
And state, are there any motions on this case?
No, Your Honor.
All right, so this case is starting out as a DWI first offense, is that correct?
Yes, Your Honor.
All right, Mr. De La Fuente, and cause 658065 to the charge of driving while intoxicated, first offense that he pleads, sir.
My client pleads no contest, Your Honor.
Yes, sir.
Court accepts the plea of no contest to the offense of driving while intoxicated, first offense. Is there an agreement?
Yes, Judge. The agreement is an $850 fine with court costs, 14 months deferred adjudication, DWI education course, victim impact panel, CAT SNP, Smart Start Mobile or Lifesaver for half the term, a mental health evaluation, 60 hours of community service, that's 6-0. 0 possession of weapons and firearms, reimbursement of $60 to the Texas Department of Public Safety, an agreed motion to forfeit the weapon.
I'd like to speak to that on, that's not agreed to.
What part?
Okay,
The
let the lady finish it, and then you come back and we'll talk about that. Randy, go ahead.
Thanks.
And the state has agreed to take into consideration cause number 658066, which is a unlawful carry of a weapon.
All right, and Mr. Griner, is this one you were telling me about the other day where part of your plea or part of your fee is going to be to get the handgun back, I guess, something like that?
Yes, Your Honor. And my
Uh,
client has gifted it to me. Is that right, Mr. De La Fuente?
Yes, sir, of course. Thank you for everything.
Okay, state, I understand that this is above your level, but the state has a policy of wanting to destroy all these guns. Does that sound right?
Yes, Your Honor.
In this particular case, and always in the past for the last, I don't know, 18 years that I've been sitting here, the policy has always been that we have awarded these defendant handguns or whatever kind of rifle, pistol, shotgun to defense counsel with the understanding they're not to be returned to the defendant, his family, or his friends. Will the state in this particular case agree with the court that the state can make a recommendation of destruction of the weapon, but I have the ability to award it to defense counsel pursuant to their original plea, or rather contract of employment?
State would agree, Judge.
All right. Mr. Griner, I'm going to award this weapon to you with the understanding it's not to be returned to Mr. De La Fuente's or his family or his friends. Fair enough?
That's fair enough, nor my wife.
And is it, other than that, is the plea bargain as you understand it, Mr. Griner?
Yes, Your Honor.
All right, let's make sure I get this right. Mr. De La Fuente, in cause 658-065, the court accepts your plea of no contest to the offense of driving while intoxicated. First offense, although I have enough evidence to find you guilty, I'm going to withhold a finding of guilt, place you on 14 months deferred adjudication probation, assess an $850 fine plus court costs, DWI education, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, either a Smart Start mobile home interlock. Does he already have a Smart Start mobile, Randy?
I don't believe so, but he does work and he does drive a company vehicle. So the Smart Start would be, the
My
portable would be.
the Smart Start company, for whatever reason, has run out of these units. So it's going to be either a Smart Start mobile. I would prefer Smart Start if you can get one, but the new replacement is called Life Safer, SAFER, and it's going to be 4 blows a day for half the term, which is 7 months. Taking into consideration clause 658-066, which is granted, it shall be dismissed. And firearm is awarded to defense counsel with additional attorney's fees not to be returned to the defendant, his family, or his friends, and 60 hours community service. That sound right, state?
Yes, Your Honor.
Yeah, that sound right, defense?
Yes, Your Honor.
Good luck, Mr. De La Fuente. Thank you, Mr. Griner. Susan, would you please advise Mr. De La Fuente and whoever else may be going on probation what they need to do?
Thank you, boss.
Yes. Anyone placed on probation today, I'll give you a telephone number. The probation department will be reaching out to you. If you have not heard from them within 72 business hours, you need to call them at 210-335-7446. And I will put that number into the chat. It is your responsibility to make sure that you go to this orientation and that you sign your conditions, because failure to do so will result in the judge issuing a new warrant from your arrest. Does anyone being placed on probation today, Mr. Mercedes or De La Fuentes, have any questions?
Okay, I just want to be correct. So within 72 hours, if I don't get a phone call, I make that phone call as soon as possible.
Yes.
Yes, ma'am. Thank you. That's all I need to know.
And just to let them know that you were placed on probation today and you need an intake appointment, orientation.
Yes, ma'am. Thank you.
All right. Your
All
Honor, Mr. Hernandez is here with his defendant. I'm going to be calling the interpreter to sign in now.
Are you able to make contact with Ms. Green yet? I
At
don't want,
this point, I have not. She did not answer. I've texted her.
all right, get set up with the interpreter if you would, and I'm gonna take a
Yeah.
5-minute break and try to call her and see if we can find a time frame that we can tell the defendant. I'll be right back. And my controls on my Zoom are not set up at this time for interpretation, I don't think.
Benavides, in 6, we can now have the interpreter, the attorney and the
Pat's
defendant.
gonna do that for us when she's off the phone, Judge.
No, it's on Zoom. Yeah, she came in and then we waited. They just came in now. Okay. Thank you. Okay, Mr. Hernandez, they should be coming in, and then at that point, I will enable the interpretation.
Okay, thank you very much, Ben.
You're welcome. I have to wait until they sign in so that I can put them in.
Okay, and is my volume coming through clear? 'Cause
Yes,
I've-
you're doing fine. Everything is fine.
Okay, perfect. Thank you.
Mhm.
Okay, can everybody hear me?
Yes, sir.
Mr.
Yes, sir.
Maldonado, I spoke to Miss Green and she sounds like a frog. She, poor thing, she's very sick. She said tomorrow afternoon at 2 o'clock, we can do this on Zoom. Is that gonna work for you, sir?
Yes, sir.
Judge,
If you have something to write on, I'll give you our Zoom or numbers. Pat, I assume we're using our standard Zoom for tomorrow, correct?
Tomorrow at what time, Your Honor?
2.
Okay.
Judge, I won't be available. I'll have to get a substitute in.
Okay, you get us a substitute, please.
All right.
Yes, Your Honor. It'll be the regular sign in, Your Honor.
Okay, Mr. Maldonado, this is our regular sign in on Zoom, 935-061-3978. And then the second number is 532228.
I will
Okay.
send you also a link, Mr. Maldonado.
Okay.
All right,
Later
thanks
this
very much,
afternoon.
sir. We'll see you tomorrow.
All right. Thank you.
Bye-bye.
Bye.
All right, which one are we gonna do next?
Your Honor, you can do, well, the only one that would be here would be Suzanne, that is the MTR. I'm waiting for the interpreter to come in.
Okay. Ms. Kramer, are you ready to proceed? And you have something you wanted to discuss before going into this, I think.
Yes, Judge. And I just got a hold of Bob on Kelly. I don't know if you've heard back from Kelly. He just texted me she's sick, and I said, yes, the judge knows. He just wants a reset date available for her. So maybe
Yeah,
he'll text me
she
back.
agreed to tomorrow at 2 o'clock on
Oh,
Zoom.
okay. Well, then never
And
mind.
I'll get with Bob. Bob may be the one that doesn't really matter.
Okay, the interpreter has come in, Your Honor, and once he is totally signed in, I can do the interpretation.
Okay.
I'm gonna
Ms.
do
Kramer?
it.
All right, this is cause 550-723, State of Texas versus and I apologize, I may not pronounce this right, Tri-El-Ho. Does that sound right, Suzanne?
Yes, Judge.
Mr. Ho, is that correct?
Yes, sir.
All right. And Ms. Kramer, you needed to chat with the court and the state over this case before.
I've already spoken with Karina on this, Judge. I guess, I mean, I really do have an offer to you, but you know, you might as well just call the case and then I can talk to you about it because we're going to end up pleading true to one of the conditions. So.
Okay. Well, let's just do it, and then you can feel free to bring up whatever you want to bring up. This is cause number 550723, State of Texas versus Tri-El-Ho. This is a motion to enter adjudication of guilt and revoke community supervision. The first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purports to have both Mr. Ho's and Ms. Kramer's signature on it. In fact, Mr. Ho, is this your signature on this document, sir?
Yes, sir.
Thank you. And Ms. Kramer, as attorney for Mr. Ho, is this also your signature on this document?
Yes, Judge.
Thank you. The next document I am looking at is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication and the defendant has a limited right of appeal, unquote. Is this your signature on this document also, Mr. Ho?
Yes, sir.
And Ms. Kramer, as attorney for Mr. Ho, is this also your signature on this document?
Yes, Judge.
Once again, cause number 550723 is a motion to enter adjudication of guilt and revoke community supervision. Ms. Kramer, my understanding is that this is going to be an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
Yes, Judge. I would prefer not to plead true to the 4 number 2s, but I will plead true to the, I think it's 14, which is the community service.
Okay. So Mr. Ho, in cause 550723, on the motion to enter adjudication of guilt and revoke community supervision, how do you plead, sir?
What does that mean?
And Suzanne,
Mr.
you're
Ho-
welcome to come in here. I mean, Suzanne, you can enter a plea for him if y'all have already agreed to what you want to do.
We have, remember, Mr. Ho, I said that we won't plead to the marijuana allegations, but since you did not do community service, we will let the judge know that is true.
Yes, sir. Yes, ma'am.
Okay, that's what he's asking. So he'll plead true, Judge, to the, I think it's number 14.
So I have number 14 is not completing community service. And I have number 2, and for the record, I'll say condition 2A, 2B, 2C, and 2D, which are 4 different allegations of testing positive for marijuana, it would appear. So what is he pleading to? I'm sorry?
Number 14, Judge.
All right, fair enough. And Ms. Kramer, would you please, excuse me, Ms. Gross, would you please advise the court and the parties of the status of Mr. Ho's probation? I remind you, you're still under oath.
Yes, Your Honor. Good morning. Mr. Ho did fairly well with regards to his reporting. He did miss 1 month. His case is paid in full. I have no record of any of his 48 hours of community service having been completed. He did complete a drug offender education program. He had 1 failure to submit to drug testing and 5 positives for marijuana. This is his first violation report, first MTR, and he has a prior arrest for a possession of marijuana 0 to 2 ounces. This case did expire back on May 19th of 2019, and his officer is recommending revocation.
And Ms. Kramer, what are you requesting?
Well, Judge, as you know, Mr. Ho is paid in full and he did his DOEP. He has had no issues. Obviously, this case is very old, 2019. He thought that it had been completed already. And that is a frequent thing we hear from people. And he's had no problems. He has a good job at a restaurant. I couldn't really hear the name of it. It looks like sounded like it was Heavenly, but he's a waiter at a restaurant for well over a year. And what I wanted to see, because your choices are revocation or termination, since he did the DOEP and he paid in full, and it's not like he's been smoking marijuana this whole time. We don't know, but I sincerely doubt it because he's maintaining his employment. If he paid $480 to one of the Wounded Warrior charities, I guess online today, and I told him I would want to see it if you agree to this paid by noon, would you then consider if we could get verification of that now that he would have community service finished, consider, since it's so old and he's gotten into no further trouble, terminating the case?
State, is my understanding correct that your office currently has a policy of not even prosecuting possession of marijuana 0 to 2 ounces unless it's in a school zone or there's some aggravating factor? Maybe it's with an additional offense or something. Is that the standard operating procedure for the current Bexar County Criminal District Attorney's Office?
Yes, Your Honor, we do prosecute those cases, but in limited instances, like you just stated.
I got you. What is the state recommendation on Mr. Ho's case, please?
The state's recommendation, defense and I talked about that, and the state would be fine with terming him if he made that donation.
And Susan, what was the original fine amount on this?
Judge, he did not have a fine assessed by the previous judge.
Okay, $0 fine then?
Correct.
Although he's paid in full of his court costs, correct, Susan, and supervisory fees, all the rest of that?
Yes, everything is paid in full.
How did this case get so old? Just because of the court it was in and they just basically neglected it? Does that sound right?
That does sound about how that works out of that court.
Okay, I got a plan. Mr. Ho, in cause 550723, the court accepts your plea of true to condition 14. I grant the state's motion to revoke your deferred adjudication probation. I adjudicate you guilty of the offense of possession of marijuana, 0 to 2 ounces. I sentence you to 15 days in the Bexar County Jail. Assess a $0 fine plus court costs, credit for time served, time and money to run concurrent, judgment satisfied. Anything further from the state or the defense on Mr. Ho?
No, from the state judge.
And if you could please put me back, or Pat, if you could send him back to the breakout room he was in so I could explain to him what just happened.
All right, good luck, Mr. Ho. Thank you, Ms. Kramer.
Thank you so much, Judge.
And Tony, you ready on your guys? Or are we ready on the translation side of the house, I guess is the actual question?
I believe we are, Judge.
Ooh, there's my translation button.
Just let me just have Mr. Mercedes unmute.
Okay, yeah, I sure can. Sure.
Sí,
Claro que sí.
okay, good.
Ahí me escucha. Sí. Sí, ese soy yo. Ok. Gracias a ti.
All right, Mr. Hernandez, are you ready to proceed? Mr. Hernandez, your microphone's turned off. There you go. Cause number 657-691, State of Texas versus Victor Mercedes. Mr. Mercedes, did I get, Pat? I don't have documents with regard to Mr. Mercedes
I
on.
included them in the ones that I sent you for Mr. Hayward. They were scanned because they had signed everything yesterday. And so they should be in the same email that Mr. Hayward.
I apologize. Let me go off camera for a minute. Let's cross our T's and dot our I's. Okay, Pat, I do not have those documents. Can you resend them? I have everything except the cover sheet that's supposed to say defendant's consent to plea by video conference. I don't have that document.
We did not do that yesterday, Judge.
Your Honor, that I completely forgot.
Yes, so, and
All right, we're gonna need that. Can we take a quick break and y'all can do that real quick and get it over to us?
Certainly.
All right.
I will send it, Your Honor, to him. I apologize.
No problem. No big thing. Okay, who else are we ready on? Let's see.
Mr. Pettis.
I'm here, Judge.
Perez, are you ready to proceed on Mr. Hayworth?
Yes, sir. Sorry, I was having connectivity problems, but I'm good to go now.
All right. This is cause number 423-255, State of Texas versus Charles Hayworth. This is a motion to revoke community supervision. The first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which is purportedly signed both by Mr. Hayworth and his attorney, Mr. Perez. In fact, Mr. Hayworth, is this your signature on this document, sir?
Yes, it is, Your Honor.
And Mr. Perez, attorney for Mr. Hayworth, is this your signature on this document, sir?
Yes, sir.
Okay. Next document I'm looking at is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. In fact, Mr. Hayworth, is this your signature on this document also, sir?
Yes, it is, Your Honor.
And Mr. Perez, as attorney for Mr. Hayworth, this is also your signature on this document.
Yes, sir.
This is a motion to revoke community supervision. My understanding, Mr. Perez, is this is going to be an uncontested motion to revoke community supervision. Is that correct?
Yes, sir.
Mr. Hayworth, in cause 423255 on the motion to revoke community supervision, how do you plead, sir?
I plead true.
Thank you, sir. Ms. Gross, would you please advise the court and the parties of the status of Mr. Hayworth's probation? I remind you, you're still under oath.
Yes, Your Honor. Mr. Hayworth has performed very poorly on probation. His case was transferred out of county originally to the Houston area. And we have no record of any payments having been made to Bexar County, and he has a balance of $1,772. He did have 48 hours community service, which the court probated. We have no record of him ever obtaining an ignition interlock device. We have no record of enrollment or completion in a DWI education, victim impact panel, or attending an outpatient program through the Veterans Administration. This is his first violation report, first MTR. This is his only known criminal history in Bexar County, and his officer is recommending revocation. This case expired May 19th, 2015.
Okay, Mr. Perez, what are you requesting, sir?
First, Judge, I offered defense 1 and defense 2. I sent it to you directly in chat, and I also sent it to the ADA. Judge, me and the ADA are agreed on a 14-day judgment satisfied. We're asking the court to respectfully grant that. Long story short, my client did about 2 weeks in jail. He pled to this case, but he was homeless, an alcoholic, and a drug addict, and essentially he jumped a train out of state and has been missing since then. Now, since then, he's completely changed his life around. He's applying for a federal job, and he needs to get this out of the way. He has, as you'll see in defense 2, he has a letter from the VA showing that he has completed a residential substance abuse treatment program in 2018. He did complete a non-combat PTSD program also in 2018. And he did also complete mental health treatment and the HOPE program, which also addresses mental health needs. I did send you a letter from the VA as Defense Exhibit 2, pending any objection from the state. I also sent you a certificate of completion that he's completed a peer specialist certification from the Wisconsin Department of Health in 2021, which I sent to you pending any objection as defense 1. So, Judge, bottom line, he's been absconded for a while, but he has turned his life around. He has substantial documentation from the VA. I was hoping you would JSAT him.
Let me back up. I have not received those documents. I'm looking for them right now. That when I say I haven't received them, that doesn't mean I haven't received them, but I haven't seen them yet, and I'm not finding them. Were they sent yesterday? Is that correct?
No, sir. They were sent right now on chat right here on Zoom. So
they're on
you should
Zoom.
have them in the chat function. Yes, sir.
So how do I access these? Chat room?
Chat.
Oh, I see them. Hang on a second. Give me a minute. Look at these.
Yes, sir.
I can't get them to open for whatever reason. Let's try again. For Defense Exhibit 1 for identification, what is that document?
Your Honor, that's a certificate of completion from the Wisconsin Department of Health Services showing that he's completed a peer specialist certification requirements. My understanding of a peer specialist is basically somebody that helps others overcome addiction. That's defense 1.
Okay, and then what is 2?
Defense 2 is a letter from the Department of Veteran Affairs to Maya, Wisconsin, stating that Mr. Hayworth has completed residential substance abuse treatment, non-combat PTSD program, that he completed additional mental health treatment to include the HOPE program, and that he is presently serving as a house manager. The letter goes on to say that he's shown excellent insight into his treatment needs and has pursued all treatments available. His ongoing sobriety has surpassed 4 years. It essentially goes on to say that the VA believes that he's made leaps and bounds and in his maintaining his sobriety, Your Honor.
First off, I assume you're offering defense exhibits 1 and 2 for identification into evidence for purposes of use in this hearing only.
Yes, sir.
Is that correct?
Yes, sir.
State, do you any objection to defense exhibit 1 or 2 for identification?
No objections, Judge.
They shall both be admitted. Mr. Perez, do I have your permission to chat with your client about his military background?
Yes, sir.
Hey, Mr. Hayworth, what'd you do in the military, sir?
I was in the Navy and I served aboard a ballistic submarine as a nuclear engineering chemist, mechanic, and radiation health expert.
We can't punish you any worse. You've already punished yourself joining the Navy. I can't top that. Did you get an honorable discharge, sir?
Yes, sir, I did.
Okay. So that's why his community service hours are probated, I'm assuming. What is this new job that you're applying for? It's a federal employment situation?
It's in the same RRTP program in which I've gone through that was on that piece of paper. It's a rehabilitation and recovery program where I'd be serving as a social service aide. It's basically a way to get my foot in work towards the peer support job I really want. But I'll start, somewhere, and that's as a social service aide where I will be helping veterans when they come in and on their daily basic going through the program. Any of the small stuff that's needed is what I'll be doing.
And are you currently working now in some other job position other than that one?
Yes, sir. Now, as of now, I'm an ambassador to the program and also a peer helper.
And do they pay you for that?
Yeah, I get $9 an hour.
Okay.
It's a CWT job.
Let me address a couple issues that Mr. Perez brought up. Number one, Mr. Perez indicated that he and the state had agreed on an outcome for this case. And I want to remind everybody and make sure it's clear and we're all on the same sheet of music that I am not bound by any agreement that the defense and the state may have entered into. Is that your understanding, Mr. Perez?
Yes, sir. I'm aware that you decide what happens in this case. And I think I made that clear to my client the last time we spoke.
Ms. Sanchez, is that also your understanding?
Yes, Your Honor.
All right, but obviously you are certainly welcome to make any recommendations, and you can say that you each agree to the same outcome, and that's perfectly fine. I'm just not bound by it. So you understand that that's what the law says, Mr. Hayward?
I understand.
Okay. Go ahead, if you would, Mr. President, tell me what you and the state have agreed to.
Judge, he's done 14 days in the county jail previously. I know that his progress on probation was dismal, but he has made substantial progress on his own, changing his life around. And he does have the opportunity now to become, a productive member of society by establishing that federal job. So I would like, Your Honor, if you would adjudicate him guilty, revoke his probation, sentence him to the 14 days he's already done, and satisfy his judgment. And I believe the state is agreed to that recommendation.
Well, apparently he's already been found. He's not on deferred, it doesn't appear, is it?
No, sir.
So he's already been convicted of obstruction of a highway or a passageway, I think.
Yes, sir.
Probably shouldn't get anybody too excited. All right. Here's what I'm thinking, and we've done this quite often in the past. in the nicest possible way, don't agree that justice will be served by the agreement that the defense and the state have entered into. However, this is what I proposed to the defense and the state as an outcome. And I would like Mr. Perez, if he wishes, to go back in a chat room and chat with Mr. Hayworth about this. If I were to do the textbook solution and revoke Mr. Hayworth and sentence him to the maximum sentence allowed by law, which is going to be 6 months in jail and what fine is on this one, Susan?
Judge, he was originally a BTC participant and that didn't work out. So he still has that fee on his court ordered fees. And when he was apparently kicked out of the BTC and put on this standard regular probation, there was no fine assessed. So I guess it was considered at the time that that $1,000 fee would be part of his fine.
Okay.
et cetera.
What year was Mr. Hayworth in the Veterans Treatment Court? Do we know?
2014.
And Mr. Hayworth, did you actually go through a hearing with the Veterans Treatment Court, and then you were like you had a track one or something that was terminated, and you went to regular probation? Does that sound right?
I saw the judge when I was serving time in jail when I finally had any kind of hearing.
Okay, but when you were, I guess you were kicked out of the Veterans Treatment Court for violations. Does that sound right?
I just never showed back up. I mean, like I said, I was released from jail.
I've got you.
And it was only a few months later that I moved out of state.
I've got you. All right. Here's what I propose is what I think would be fair under the circumstances. Obviously, Mr. Hayworth is out of state. What state are you in currently, sir?
The state of Wisconsin, Your Honor.
He's in Wisconsin. Now, the good news is he's turned his life around and he's got good job offers coming up. The bad news is we have this problem down here. I anticipate that justice would be best served by me revoking Mr. Hayworth, giving him a maximum sentence of 6 months in Bexar County Jail, $1,000 fine plus court cost, credit for time served, time and money to run concurrent, and give him 30 days to show up and start his jail sentence. However, in that 30 days, if he were to pay off the $1,772 he owes Bexar County, I would waive his jail sentence. He's still gonna, I mean, he has a conviction for the crime now anyway. I'm not affecting that. That's already there. All this does is get him to pay for his colorful activities back then. And then he will have no jail sentence whatsoever.
What was the amount, Your Honor?
Say again, sir?
The amount, sir?
$1,772, Susan, is that correct?
Yes, Your Honor, plus the $2 processing fee.
$1,774. Y'all want to go in a chat room and talk about that?
Yes, sir.
Yes,
All right.
sir.
Feel free to do that. Take all the time you need.
All right, Mr. Pettis, I'm putting you in room 5, Mr. Hayworth in room 5. Your Honor, I have sent you the signed paperwork for the defendant's consent to do the plea by video conference.
Okay.
It is there, he has it. Or you have it.
It's here, okay.
And there's no place for you to sign, Your Honor, excuse me, but I was doing it, but I did send it to you in an email, completed.
Okay, give me about a 2-minute break. I'll be right back and we'll take up Mr. Mercedes if everybody's ready.
Your Honor, I'm sorry to interrupt. Are you still available, sir?
He just stepped out to get something, and so he said 2 minutes.
Okay, I think we have a deal, Pat.
Okay.
Okay, back on the record on cause 423255, State of Texas versus Charles Hayworth. Mr. Perez, were you and Mr. Hayworth able to chat about my proposed resolution?
Yes, sir, and we are agreed. And moreover, he tells me that he could pay right now. So my understanding essentially, Your Honor, is he pays $17.74 and then it'll be judgment satisfied, go forth, sin no more, right?
That would be absolutely correct. State,
He'll
would that be
pay
okay with you?
Yes, Judge.
Yes,
All right. Mr. Hayworth, in cause 423255, State of Texas versus Charles Hayworth, the court accepts your plea of true. I grant the state's motion to revoke your probation. I sentence you to 6 months in the Bexar County Jail. Assess a $1,000 fine plus court costs, credit for time served, time and money to run concurrent. You are ordered to report to the Bexar County Jail on, today is the 13th, August the 15th, 2022. However, if you pay the amount of money that you still owe Bexar County, which is going to be $1,772 plus a $2 processing fee, so a total of $1,774 prior to that date and time, I will waive your jail sentence. You would report to the Bexar County Jail on that date and time. My understanding is that hopefully we can have the financial issues resolved this week so that your jail sentence will be waived this week. Mr. Perez, is that your understanding of the agreement?
Yes, sir, it is. And prior to him being dismissed, I asked that he be put in a room with probation to arrange for those payment arrangements right now.
Ms. Gross, can we do that?
Yes, Judge, not a problem.
Thank you.
Mr. Hayward, I'm putting you in 4 with Miss Gross.
Good luck, Mr. Hayworth. Is that it, Your Honor? Maybe
That's it. Thank you very much, Mr. Perez. Good luck, Mr. Hayward.
Thank you, sir.
Tony, let me do some writing, then we're going to jump on yours.
Thank you, Judge.
Okay. And we've got our interpreter and everybody's good. This is cause number 657691, State of Texas versus Victor Mercedes. And the first document I'm looking at, Mr. Mercedes and Mr. Hernandez, is a defendant's consent to plea by video conference, which purports to have both Mr. Mercedes and Mr. Hernandez's signature on it. In fact, Mr. Mercedes, is this your signature on this document, sir?
Sí, sí, señor.
Thank you. And Mr. Hernandez, as attorney for Mr. Mercedes, is this also your signature on this document?
It is, Your Honor.
Thank you. The second document I have for you, Mr. Mercedes, and I have one in English and one in Spanish, so I have actually two documents, both titled Defendant's Waiver of Constitutional Rights and Court's Admonitions, that purport to have your signatures on the back, effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. In fact, sir, are these your signatures, one on the English document and one on the Spanish document on the defendant's waiver of constitutional rights and court's admonition?
Sí, claro que sí.
Thank you. By signing these documents, are you telling me that you've had enough time to either read these documents or have them read to you in their entirety, so that in signing these documents, you're telling me that you agree with and understand everything on these documents? Is that correct, Mr. Mercedes?
Sí, señor. Así es.
Thank you. Mr. Hernandez, as attorney for Mr. Mercedes, have you had enough time to go over this case with him? And in your opinion, is he mentally competent?
Yes, Your Honor.
Mr. Mercedes, are you a United States citizen, sir?
Sí, señor.
Mr. Hernandez, is that true? Mr. Mercedes is a United States citizen?
That is my understanding, Judge. He was
Okay.
born in Puerto Rico.
All right, perfect. I don't need to mess with that then. Mr. Hernandez, as attorney for Mr. Mercedes, has the state fully complied with discovery for you on this case?
Yes, Your Honor.
Mr. Mercedes, in cause 657691, to the charge of driving while intoxicated, first offense, how do you plead, sir?
Culpable.
Is there an agreement for Mr. Mercedes?
Yes, Judge. The agreement would be a $0 fine with court costs, 3 days in the Bexar County Jail, credit for time served, the time and money to run concurrently. And if it pleases the court, the judgment would be satisfied.
Is that your understanding, Mr. Hernandez?
It is, Your Honor.
Mr. Mercedes, in cause 657691, the court accepts your plea of guilty to the offense of driving while intoxicated, first offense. I find you guilty. I assess 3 days in the Bexar County Jail, a $0 fine plus court costs, credit for time served, time and money to run concurrent, judgment satisfied. Anything further from the state or the defense on Mr. Mercedes?
Not from the state, Judge.
Nothing from the state, the defense, Your
Mr.
Honor.
Mercedes, thank you, Mr. Hernandez.
Thank you, Judge. May we be excused?
Gracias
Absolutely.
a usted. Buen día.
Yes, sir. Thank you, sir.
Thank you, Mr. Chavez. Appreciate it. Bye-bye.
Thank you.
Thank you.
And we got that
Gracias.
one,
Thank you.
and we got this one, and that's all I got, Pat, correct?
Okay,